So justice will come to order, and clerk will open the roll.
Mr. Chair, you have a quorum.
Awesome. All right, Delegate Gilbert. 988.
Good morning, Mr. Chairman.
Good morning.
House Bill 988 is a small, simple bill.
Todd, I think 988 looks to be in good order. It seems to be clarifying, dealing with discovery and what Commonwealth can turn over. Any questions? Steve, seem to be in good shape.
Different Commonwealth attorneys' offices deal with this differently because they
Right.
don't know what to do. They don't think they can turn it over, and some think they can.
I think there was a suggestion to add some language at the end of 248. Come on, hop two.
That's correct, Mr. Chairman. At the end of line 248, staff envisioned the situation where a judge might want to see somebody's criminal history record. And apparently from jurisdiction to jurisdiction, there's different practices. And so we would suggest adding words that embrace the concept or for review by the court.
All right.
Move that amendment.
It's been moved and seconded. All in favor of adopting that amendment signify by saying aye.
Aye.
All opposed. That amendment's adopted. Any questions for Delegate Gilbert?
Move to report as amended.
Any member of the audience wish to speak for or against the bill? Senator Norman moves. Senator Reeves seconds. The bill be reported as amended. Clerk will open the roll.
Ayes 9, no 0.
And 1008.
That is a bill brought to me by the Supreme Court. Apparently, when there's a period of post-release supervision, some judges have interpreted the statute as written to mean that they can suspend the supervisory period and not the period of incarceration. This would be a situation where a jury, and most likely a jury would give a period of incarceration, and then the judge would uphold the entire jury sentence. And they just want to clarify that the judge can suspend the post-release supervision period, or the
Right.
incarceration period.
And no fiscal impact?
I don't believe so.
All right. Any questions for the patron? Anybody in the audience wish to speak to this bill?
Supreme Court's here if you need any questions answered. I'm
I
happy
see
to.
Mr. Madden behind you, too.
Okay.
You want to say something, Brian?
Mr. Chairman, Brian Madden, I'm the Commonwealth Attorney of Warren County, here today on behalf of the Virginia Association of Commonwealth Attorneys. We do support this bill. Thank you, sir.
All right. Any other questions? All right, it's been moved. Is there a second? It's been moved and second. The bill be reported. Clerk will open the roll. All right,
Ayes 9, no 0.
Warren.
House Bill 1015, Mr. Chairman.
House Bill 1015.
This is just a policy decision, Mr. Chairman. For years, we've been adding to the list of things. I know you added one at my request when I was an assistant Commonwealth attorney on gangs. List of things that the multi-jurisdictional grand jury can investigate. I would just briefly like to list for you what is already contained. I think it's longer than the list that's not. Securities Act, abduction, embezzlement, extortion, computer crimes, drugs, gambling, perjury, bribery, felony obstruction, Government Frauds Act, investigation of medical providers, conspiracy to rig bids to government, animal cruelty, murder, gang participation, false representations to obtain credit, credit card offenses, trademark infringement, insurance fraud. It's longer than that. I'll stop.
To your point, we also have House Bill 304, Delegate Watt's bill adding Consumer Protection Act and certain fraud crimes. I mean, I guess we're going to keep seeing these every year until we do this.
I think the list is much smaller of things that are not on there at this point, or at least of things that are important. And just briefly, things that are not on there: burglary, terrorism, firearms-related offenses, family sex offenses, child pornography. So those will all be bills that'll be before us soon enough if we don't finish this Christmas tree.
All right. Anybody have any questions of the patron? Senator Peterson.
I appreciate the intent of the bill, but shouldn't we just have a substitute that simply says you could have a multi-jurisdictional grand jury for any crime which is chargeable as a felony?
I think that's what this does.
Well, I mean, then couldn't we strike all the other text between lines 10 and 47?
I hear what you're saying. I think, Senator, the drafting issue related to the fact that the original draft just said you can investigate any crime, and it was a short and sweet, one word, bunch of striking, but then that put us in a posture where we were saying that a grand jury could investigate misdemeanors, and just the way it was drafted, we didn't want to get into investigating misdemeanors in the multi-jurisdictional grand jury, so I think it was just a drafting decision.
Okay, well, final question.
But I support your intent, absolutely.
Senator Peterson.
Yeah, I was just gonna say, if we're saying that any other law of the Commonwealth for which punishment as a felony is authorized, we can have a multi-jurisdictional grand jury, then why do we even enumerate the other list? I mean, then by definition, it's superfluous.
I totally agree. If council has a draft, I know you don't have one ready, but I'd be delighted for staff to work on one in concept, if
Well,
y'all do in concept over here. Like,
Couldn't you just strike and strike any law of the Commonwealth for which punishment as a felony is authorized?
Yeah, I just wanted to capture felonies, not misdemeanors, so
Charles?
however we do that.
We can do that, Mr. Chairman.
I mean, does that work?
Yeah.
Well, I'll make that amendment.
All right, it's been moved and seconded. Any discussion? All in favor signify by saying aye. Aye. All opposed? Steve,
Only to, I think that
do we
the-
need to unwind that?
No, not at all. I wanted to say that I think this is the right approach as opposed to each year adding offenses, and I've actually long advocated for that. So I think for that reason, it makes a lot of sense. I should point out to the committee, however, that when we talk about the function of the multi-jurisdictional grand jury being to investigate, which makes tremendous sense, the whole idea was that in many situations you need a multi-jurisdictional grand jury to investigate certain types of crimes. But the power also includes the power to indict. And some jurisdictions, if not many jurisdictions, will routinely go to a multi-jurisdictional grand jury to obtain just ordinary indictments because it's more convenient or for other reasons. And the effect is then that instead of a grand jury composed solely of citizens of a community, a city, or a county passing on whether an indictment should be issued, you have citizens from surrounding jurisdictions voting on an indictment just for one jurisdiction. I only point that out so that the committee is aware of it. I think that the approach, however, is correct and a good one.
Does the type of ham sandwich matter?
Well, actually, it does. Citizens of the city of Richmond might not feel that a particular set of circumstances justify an indictment, but if you combine in citizens from Chesterfield, Henrico, Hanover, oh yeah, sure, no problem. So yeah, it does matter because the grand jury is theoretically a shield and a protection for our basic rights. Having
Okay.
said that, I think it's a good idea to proceed in this fashion as opposed to what we've been doing.
All right.
Mr. Chairman?
Any other questions?
Yeah, Mr. Chairman, I have a couple of questions. I note that, the attorney for the Commonwealth in particular jurisdiction still can control the prosecution. That's still an existing law, correct?
I don't think we changed any of that.
Yeah, and to consider bills of indictment, a special grand jury, the indictment had to be prepared by a special counsel for the multi-jurisdictional grand jury. Refresh my recollection, how does a multi-grand jury get impaneled to begin with?
I think they have to apply to the circuit court and have the circuit court issue an order starting the process of the grand jury.
So, Mr. Chairman,
Senator Edwards.
any prosecutor could do that.
I believe so. I don't know if it's prosecutor or prosecutors. They are here. They could certainly answer those questions, but I'm sure that
Okay.
they can't just do it out of thin air, that the circuit court is
Yeah,
involved.
yeah, if somebody
Anybody
could
wanna bail me
refresh
out
my
back there?
recollection how that works.
Okay. None of the Commonwealth attorneys in the room want to assist us in this, Senator Edwards, so I'm just going to stand here and dangle. There we go. That's wonderful.
All right.
Morning, Michael Newman, Commonwealth Attorney, City of Danville. To answer your question, actually,
For example, I had a multi-jurisdictional grand jury. My colleague in Pittsylvania County, you actually have to apply to the Supreme Court of Virginia requesting permission and reference to have that. They then designate one of my judges for my multi-jurisdictional grand jury. It was this judge in the city of Danville, and then that's when we then get sworn in as special counsel for that multi-jurisdiction.
So, Mr.
It lasts for a year, then you extend it every 6 months.
Mr. Chairman, so any prosecutor can ask the Supreme Court to set up a multi-jurisdictional grand jury by Supreme Court order. Is that right?
That's correct.
Yeah, okay.
We have to apply to the Supreme Court for permission.
All right. Anybody else wish to speak to the bill? Yes, sir.
Mr. Chairman, Darrell Puckett, Commonwealth Attorney for Appomattox County. And I would just like to piggyback on what Mr. Newman spoke to. We've done the same thing in Appomattox County. We followed the same process with going through the Supreme Court with regards to a special grand jury. We've also been a part of a multi-jurisdictional grand jury.
All right. Charles?
Mr. Chairman, with regard to the previous amendment of striking the enumerated crimes, I do want to point out that at least some of the sections do have a felony and a misdemeanor punishment listed within the code section. So it may be a substantive change to strike all that language and say any felony, because you would be striking the misdemeanors within those
And that
code
is
sections.
precisely why we ended up drafting it the way we did.
Well, Mr. Chairman,
Senator
a
Edwards.
grand jury can indict for a misdemeanor.
We're
can't.
talking about a multi-jurisdictional grand jury. They have enumerated crimes
Yeah.
for which they can. So an example would be credit card
Yeah.
fraud. Credit card fraud has felony and misdemeanor, and when we added that to the tree, we said it could be both. So we
Right.
didn't want to take authority away.
I think we've seen this enough times. People largely know whether they like it or they don't. Senator Norman?
Move to report the bill.
All right. It's been moved. Is there a second? Second. It's been moved and seconded. The bill be reported as amended. Clerk will open the
We
roll.
have to fix that later. Okay, thank you.
All right.
Thank you, Mr. Chairman.
Thank you.
Ladies and gentlemen.
Delegate Toscano, do you have many bills? Come on up.
Mr. Chairman, which one do you want first? 1266, this is the fingerprinting for trespass
That
and
was a good
disorderly.
year. Yes.
Very good year.
I tell you what, we're going to pass that by. And for the House patrons who are here, what we're going to do is, because you all have a hard stop at 9 o'clock, we're going to handle unique bills. And unless you have an objection to the identical bills that had Senate companions being handled in the same manner, we're going to pass those by and deal with them after you guys leave.
It was reported out. The Senate bill was reported out.
It was my
Oh,
bill.
the-
It did
the
real well.
arrest Bill was 1266, the version was reported out.
Yeah.
Okay.
What's your next bill?
The closed preliminary hearings, 1364.
Yeah, okay.
I don't know if you have I don't think
Nope.
there is one in the Senate.
There is not.
Okay. Mr. Chairman, members of the committee, this was brought to me by some people in the Fluvanna Juvenile Domestic Relations Court who were finding that judges felt they didn't have the authority to order closed hearings in certain kind of child pornography or child victim cases. And what this does is give permissive authority to judges to order closed hearings for an increased number of offenses that are related to child pornography, unlawful creation of images of another. It's permissive, it's not required, so judge can.
And my understanding is there's some discussion of this bill over the weekend and maybe some thoughts as to how it might be able to be tinkered with. Charles or Steve?
Mr. Chairman, we recognize that the bill makes a tremendous amount of sense and understand that. The problem is that for any defendant, there's a Sixth Amendment right to a public trial, which includes a right to a public pretrial hearing. There's also a First Amendment right of the public to access to trials and to preliminary hearings. What's interesting is that current law already has this problem, but we're not responsible for that. Adding these provisions would be unconstitutional. It's possible. It's possible, however, if this were,
Take that, Mr. Leader.
It's a pesky thing.
yeah, it's a pesky thing. It's a great idea, but I'm concerned that it would be used in an unconstitutional manner, if not unconstitutional on its face. In
That
certain,
being said,
that said.
That being said,
I think that the courts already have the power on a case-by-case basis to preclude or to seal a courtroom. And it's that case-by-case basis that meets constitutional muster. If on a case-by-case basis, the public has the right to a hearing and to notice that a hearing might be closed, and the court is required to make a finding, then it can be accomplished. And that's under current law. We already have that right.
Mr. Chairman,
Senator Edwards.
this is only at a preliminary hearing, is that right?
yes, sir. Yes, sir.
Steve.
And the right to
Well-
public trials and the right of the public to access to trials includes preliminary hearings.
All right. Let's hear from, you've got a helpline standing behind you, maybe.
Excuse me, sir.
Other
Sorry.
shoulder.
How are you doing today?
I'm doing great. How about you?
Michael Newman again, Commonwealth Attorney, City of Danville for VACA. Respectfully disagree with Mr. Benjamin. There's no constitutional right to a preliminary hearing. It's statutory. Therefore, you're not violating a constitutional right. There's no constitutional right to a preliminary hearing. It's statutory right.
But if you
So-
have a preliminary hearing, is there a constitutional right to have it open?
No, as Mr. Benjamin's pointed out, there are already cases in which this is allowed in reference to doing. This is just simply adding what's already in the law in reference to allowing in certain cases where.
Mr.
Senator Deeds.
Chairman, council's argument's correct. If it's correct, it's correct. As to the existing statute, this bill is completely consistent with what we've done in the past. I move to report.
All right. Anybody from the audience wish to speak to the bill? Steve?
Just because we've done it in the past doesn't make it constitutional. I mean, seriously, we discriminated on the basis of race in the past, and today it's unconstitutional.
Mr. Chairman,
Who's that?
that's me.
Oh, you? Yes, sir.
No, I think the protections, the constitutional protections exist independent of what's in this statute now or what would be in the statute in the future. And it would be, I would think, subject to challenge if a judge tried to close and somebody asserted their constitutional right to say it shouldn't be closed. And then you would have a hearing. And I imagine that already happens under the statute in certain circumstances.
All right. Anybody from the audience wish to speak? Senator Deeds has made a motion to report. Is there a second?
Second.
It's been moved and seconded. The clerk will open the roll.
Ayes 5, noes 9.
All right, bill fails to report.
Thank you.
Thank you. Next, Delegate Leftwich. Let's see whether we can roll through your impressive stack of bills. And Kristen, I think I'm going to need some help figuring out which ones are not analog bills. All right, let's take up 746 first. Now, 746 is a trust and estates bill. My understanding is it comes from trust and estates section of the Virginia Bar.
Yes, and they're behind us, Your Honor.
Your Honor, thank you.
Mr. Chairman. So basically, there are some default provisions that, for the interpretation of wills, and for consistency's sake, this bill would have the same default provisions apply to revocable trusts. That's revocable trust only, not irrevocable trusts.
Okay, so whether it's in a will or in an independent trust?
Revocable trust, yes, sir.
Yeah. All right, anybody have any questions? Anybody from the audience wish to speak?
If I can ask a question, Mr.
Senator Deeds, of course.
As I read lines 15 through 21, you're basically saying that if you can prove by clear and convincing evidence that the testator didn't prove or didn't intend what the will says he intended.
What I interpret that to mean is that if there's an ambiguity.
But it says, even in line 15, it says, even if unambiguous.
Yes, I can get, let me,
All right, you got a helpline.
Good morning. My name's Tom Yates. I'm with I'm the Wills and Trust section of the Virginia Bar Association. I'm a lawyer in Fairfax, Virginia. Currently under the Uniform, I'm going to back up, Senator Deeds. Under the Uniform Trust Code, you can reform a trust if there's a mistake of law or fact, or to conform with the settlor's probable tax objectives if you can prove by clear and convincing evidence what their intentions were. And this is taking the trust law and extending it to wills.
But, Mr. Chair, Mr. Yates, you would agree with me that this would be something completely new and go against centuries of jurisprudence with respect to the interpretation of wills in Virginia.
It is an expansion of the interpretation of wills to permit outside evidence, yes.
Has this been done in other states?
Yes, it has. It's part of the Uniform Probate Code.
This is?
Yes, which is in several dozen states.
Okay. So we're not at the leading edge of the wave. All right. Anybody else from the audience wish to speak in favor of or in opposition to the bill? Bill is before us.
Move report.
Move to report, sir.
All right. It's been moved and seconded the bill be reported. Clerk will open the roll.
Ayes 13, noes 2.
All right, next, 754. I think you're going to be Legislator of the Year for the Virginia Bar Association.
I don't know if that's a good or bad thing, Mr. Chairman. I'm told it's a good thing.
All right. Yes, sir.
All right, so this simply makes some technical corrections to the elective share and allows a spouse's share to be satisfied with separate property if it's been given to the spouse prior to death.
All right, anybody have any questions of the patron? Anybody from the audience wish to speak in favor of or in opposition to the bill? Bar Association likes it. Senator Stewart?
What is it? What do the technical corrections do?
So the most significant one would be that if a spouse receives separate property prior to the testator's death and they die and they elected against the will, that separate gift given prior to marriage could go to satisfy that elective share. So if you had,
Even if that intent is not expressed, that just becomes a standard. What if I want to give it and I don't want it to count?
well, if you want to give it, then you would will it to them in the will. But if you cut them out of the will and they elect against the will to get their elective share, then they're getting something the testator did not intend for them to get because they cut them out of the will. So they could elect against the will, take a percentage, and what this bill would say is that if they got a gift prior to death of separate property, then that would go to satisfy that elective share. Did I answer that correctly?
Yeah.
Okay. Okay. No, it becomes part of your elective share if you elect against the will.
Mr. Chairman,
Senator McDougall.
So we have an individual, while they're alive and supposedly competent, makes a gift to a party.
Correct.
Then they've executed a testate document, they die, and then the provisions under that document were saying, now they put in that excluding my spouse from receiving under the will. I have a spouse, I'm excluding them from receiving under the will. And so now that person cannot take the elective share.
They can take the elective share.
They can't if they've gotten the gift and it counts against them, so we're saying they get nothing additional.
They take the elective share, but what was given to them prior to death would
Mr. Chairman?
be counted towards that.
Senator McDougall.
What I'm trying to understand is why would we have any action prior to death that doesn't cancel out your testamentary intent have any impact on what you can do under the will? if the person did it while they were competent and gave a gift, why should what somebody could take statutorily as their elective share be impacted by that?
Mr. Chairman, can I please help answer some of these questions?
All right.
My name is Dan Durst. I'm a partner at Williams Mullen in the Trust and Estates section. I'm also on the legislative committee of the Virginia Bar section of Wills Trust and Estates. This is really a technical correction. Most of this concept is already in the statute. So there's two things that the elective share does. One is you have to determine how much the elective share is. And the second is you have to figure out where's the money going to come from to satisfy the elective share. Right now, there are a couple concepts missing from the statute with respect to separate property. So we've tried to preserve in the statute the idea that if you received a gift during your lifetime, that your spouse can't force that separate property from your estate. There's a cross-reference that's missing currently in the statute. So the first correction is to correct that cross-reference to exclude separate property that's held in things like revocable trusts. It's already excluding separate property that's held in your probate estate. It's already excluding separate property that is passing to your spouse through your probate estate, but it's not including, it's not excluding from the elective share separate property you've decided to just hold in your trust. So there's an inconsistency there that really doesn't make any sense. And there's also just a broken cross-reference in the statute that's referring to when you're satisfying the elective share, where's the money coming from to pay the spouse when they're entitled to something? There's a broken cross-reference in the statute that's not referring to anything at all. It's the first in that list under 308.9, I think. It's making a cross-reference, and the attempt was to exclude property that was separate property that is being used to pay the spouse's separate elective share claim, that it would come first from property over which they didn't have any claim at all. But if the testator or decedent actively wanted to satisfy their claim with separate property, they could. So that's what's missing from the statute right now. I don't know, does that help?
Any other questions? All right, bills before us.
Just confused if you don't do this here.
Yeah. No, I don't think anybody's here to speak against it.
Nobody understands it.
I think that may be right. All right.
I think I understand it. I move
been
the report.
It's been moved and seconded. The bill be reported. Clerk will open the roll.
I think I understand.
Yeah. All right.
All right. Ayes 10, noes 4, abstentions 1.
Another. That's it? Okay. We're going to deal with the rest of yours in your absence.
Okay, all right.
If you trust us.
It might be
Delegate
better.
Habib.
Hell no, I wouldn't trust them.
I think I have two. I'm not sure if 378 is on your list that already has one. So 613 is my other bill. The only thing 613 tries to do, JNDR court judges realize.
613.
Yeah, JNDR court judges realize there's a whole bunch of really confidential information about children that's open to the public if you go pull their case files. So this just says that child support and custody cases will be confidential, and then it gives a list of who can get access to them. There was an amendment that says anybody with an interest in the case and you can go to the court. That is largely for lawyers who want to get involved in cases, who want to go review them.
I think it looks good. I think we've got a technical amendment. Language. Use, do we not want to use clerk or deputy clerk instead of the professional court personnel language?
That sounds like a great idea, Mr. Chairman.
I think so too.
I can't claim it's an original one.
Original thoughts are hard to find around here.
You've got in line 50 a reference to judge, court officials, and professional staff assigned to serve the court. Instead of that, I think the thought was that instead of professional staff, we use clerk or deputy clerk.
That'd be fine.
All right. Is there a motion to that effect? It's been moved and seconded. All in favor of that amendment signify by saying aye. Aye. All opposed. Anybody have any questions of the patron? Anybody from the audience wish to speak in favor of or in opposition to the bill? Yes, sir.
I'll tell you afterwards which J&DR court judges found this. I think you know.
I'm Lawrence Steele here for the Family Law Coalition. We support the bill.
All right, thank you. All right, the bill's before us as amended.
The report.
It's been moved and seconded that the bill be reported as amended. Clerk will open the roll. All right.
Ayes 15-0.
I'll let Senator Stanley's former law partner know. Thanks.
All right, Delegate Campbell.
Mr. Chairman, easy bill, fixes a loophole in the JNDR venue statute.
326, right?
Yes.
Okay. Yes, sir.
Mr. Chairman, it fixes a loophole in the JNDR venue statute that allows an alleged abuser or neglector of a child to avoid prosecution by simply secreting the child out of state before the petition's actually filed. This arose out of a real-world case.
Okay. Anybody have any questions of the patron?
Mr. Chairman, if
Senator
if the
Edwards.
child is taken to North Carolina or Tennessee or West Virginia or somewhere, you can't get them. North Carolina, West Virginia, or Tennessee have jurisdiction.
Well, under the UCCJEA, they would have jurisdiction after 6 months. What the fact pattern this arises under is when you have an investigation for abuse and neglect ongoing, and then in between the investigation, the filing of the petition, the family moves the child out of state, doesn't change the residency, child's no longer present in Virginia.
And this is for civil cases only?
Yeah, for abuse and neglect cases. Only.
Civil?
Civil, correct.
All right. Any other questions? All right. Anybody from the audience wish to speak in favor of or in opposition to the bill? Bill is before us. All right, it's been moved. Is there a second? Is there a second? All right, it's been moved and seconded the bill be reported. Clerk will open the roll.
Ayes 15-0.
All right, that bill is reported. Thank you. Next, we've got Delegate Adams.
Good morning. Thank you, Mr. Chairman,
Good
members
morning.
of the committee.
1024?
Yes, sir. House Bill 1024 comes on the recommendation of the Boyd Graves Commission with regard to a statute suggesting the repeal of a prohibition that should attorney's fees be awarded, that it may only be awarded to one attorney. Apparently, this is it's a little unclear what the reasoning was behind that, but obviously there are cases where attorneys join forces and bring different folks in. This would eliminate that prohibition.
I don't know whether I'd like it if I was that one attorney.
Right.
Having to split my fee. All right, anybody have any questions of the patron? All right, the bill is, anybody from the audience wish to speak in favor of or in opposition to the bill? All right, it's been moved and seconded. The bill be reported. Clerk will open the roll. All right.
Thank you, Mr. Chairman.
That it?
Yes, sir.
All right.
Ayes 15-0.
All right, Delegate Collins.
Good morning, Senators.
Good morning.
Which one would they, I have two before you.
Let's take 217, 278.
278, and the chairman let me know yesterday, and I think I think it was good policy. The language that we have there is basically codifying what the courts can already do, which is they can reduce a guardian ad litem's fees based upon whether or not they follow the rules of the court or the statute that we have passed before. That language, I think, should go in B at the end of the sentence there. I think.
All right. So you are talking about the costs reimbursed to the Commonwealth is what you are trying to address.
Yes, Mr. Chairman. And I'll tell you the situation. The situation is this. This came out of a 2-year work group for guardian ad litems. This was one of the recommendations. is that we have guardian ad litems that are, we have a code section that tells guardian ad litems what they need to do and how they're supposed to respond to the court, as well as for their wards and in dealing with their investigation of a case. Courts have routinely found that when guardian ad litems are not doing what they're supposed to do statutorily, some courts have felt that there was no language in the code that they could reduce a fee if they thought it was onerous. Other courts have said, I don't have that authority. And so the work group has said that we should give that court the authority to be able to determine a guardian ad litem's fees, just as with court-appointed counsel, as a court-appointed lawyer, I have judges routinely say,
All right. So, Kristen, in order to accomplish the patron's purpose, I understand that an amendment's needed.
Mr. Chairman, in order to accomplish the purpose of the court being able to reduce the amount the guardian is compensated, we would move the new language on lines 38 to 40 to line 31 at the end of subsection B.
All right. It's been moved and that amendment's been moved and seconded. All in favor signify by saying aye. Aye. All opposed?
Mr.
Right, that
Chair.
amendment's adopted. Senator Deeds.
Doesn't the court already have the authority to adjust the fee?
Mr. Chairman, Senator Deeds, they have the authority. However, what the commission found was that their courts were saying they did not have the authority because it was not statutorily set out. So we're not making new law here. What we're just codifying what we already kind of embraced, told the courts they could do. We're just telling the courts you can do this, even though certain courts were doing it and certain courts were not doing it. So this is just codifying what I think is the intention of the legislative body.
Do they do the job? All right. Any other questions? Anybody from the audience wish to speak in favor of or in opposition to the bill? Mr. Deal, good to
Lawrence
see
Deal,
you.
the coalition favors this. There is a conflict. We're a creature of statutes in family law, and if it's not there in black and white, judges may want to do this, but this will clarify that.
And this emerged from a
study on
long
guardians.
process and study.
Yes, sir.
All right. Bill is before us. Is there a motion? It's been moved and seconded. The bill be reported as amended. Clerk will open the roll. All right. You have another?
I do. House Bill 188. I'm sorry.
Hang on. Kristen.
We have a
All right. We're going to, unless you object to it being handled in the same manner in which Senator Stanley's, which you may want, no. We're gonna move on to unique bills, and I think we can probably take care of you.
Yes, sir.
All right, Delegate Klein.
I'll take care of you, Chris. Morning, Mr. Chairman.
Good morning.
I have House Bill 1212, which came in response to a ruling out of Circuit Court in Fairfax County by Judge Steve Shannon, who respects the legislature and ruled that under the signature requirements of Code Section 801-271.1, all pleadings must be signed by a licensed attorney acting as counsel of record or by a pro se litigant. It does not allow for next friends. And so because the statutory language is not explicit as to whether allowing parents to sue on behalf of a minor as next friend permits a parent to manage the lawsuit by signing and filing pleadings on the child's behalf, or whether it prohibits such activity, brought this bill to clarify that it does. There is an amendment being proposed by the AG's office to include the people who are signing for disabled individuals. I'd invite the AG's office to propose their own amendment if you have any questions otherwise.
Do you?
I don't object.
Okay. Yes, ma'am.
Good morning. I'm Brittany Anderson with the AG's office. We did propose this amendment in light of a recent case that our office handled. That was an appeal on a decision from the Department of an appeal from a decision that was made on DMAS. We had an incapacitated adult that was a DMAS recipient, and his mother tried to represent him in that appeal, and the law didn't allow for her to do that in such a manner. And so the judge in that case wrote to us and expressed concern that incapacitated adults weren't able to be represented in these manners.
Okay.
Mr. Chair.
Senator Peterson.
But this doesn't speak to incapacitated. This just is a minor.
Our amendment expands it to a DMAS recipient or somebody under public assistance.
Kristen, you have that amendment?
Mr. Chairman, on line 19, after friend, insert, in a judicial review proceeding under the Virginia Administrative Process Act involving public assistance, the legal guardian of a public assistance applicant or recipient who has been adjudicated an incapacitated person may sign the pleading motion or other paper of such an individual as his next friend.
Cap? Senator Peterson?
Yeah, I'm a little bit concerned that we're now going in a different direction from where this statute, 8.01-271.1 deals with pleadings in court, as I understand it. Now, I feel like this is a whole different issue.
Go ahead.
So, it is with it is a little bit of a different issue. Under the APA, the circuit court serves as an appellate review of a state agency's final decision.
Mr. Chair, if I might.
Senator Peterson?
I think one of the goals of the legal code is to try and keep things somewhat simple and not, I mean, every idiosyncratic situation, we could have a particular line drawn to it, but I wish there was a way you could sort of simplify or consolidate the language rather than, I mean, because 8.01-271, all of us that sign pleadings are familiar with the statute. And it's a very broad statute. And
So do these typically go in the Administrative Process Act? Brittany, do you know?
I have our social services attorney here that might be able to speak to that for us.
I mean, I deal with the 8.01 as well and share that concern. Yes, ma'am.
Yes, Chairman. Michelle Lumdia from the Attorney General's office. This was a limited situation under the APA for an applicant.
But doesn't the APA deal with what's necessary in order to appeal to a circuit court? Why put it in 801?
Well, we put it here because part of the reason is that Rule 2A:2 and 2A:4 of the Supreme Court of Virginia rules require the notice of appeal and petition for appeal that are filed with the circuit court to be signed by the appellant or his counsel, which is similar to 8.01-271.1. And because of that similarity and the requirement that any other briefs or pleadings that are filed in that appellate proceeding also be signed under 8.01-271.1, the Medicaid recipient legal guardian wasn't able to represent the recipient in court when all the court does is the appellate review. All of the essentially trial proceedings are conducted in front of the agency, and so it seemed the judge was concerned about the ability of these low-income persons to have their statutory right to access the court simply because the legal guardian couldn't sign the pleadings.
All right, thanks. All right. I'm not hearing a motion on that amendment. You may need to bring your own bill next year.
I'll move the amendment. Just
All
get
right.
it out there.
There's a motion. Is there a second? All right. Bill is before us.
Mr. Chairman?
Yes.
We had identified one other issue in the work group. The cross-reference that was added in House courts didn't seem as clear as it could have been, and we would suggest removing that language that House courts added on line 18 and instead saying, however, a parent may not sign on behalf of a minor if such signature is otherwise prohibited by subdivision 6 of 64.2-716, and that deals with conflicts of a parent being able to bind a minor in a trust or will agreement.
That's fine. All right, that amendment's been moved and seconded. All in favor of adopting that amendment signify by saying aye. Aye. All opposed? All right. The bill is before us as amended.
No,
right?
with the Second Amendment, not the first.
That's correct.
I'll move to report.
All right, it's moved and seconded. The bill will be reported as amended. Clerk will open the roll. All right.
Pass 15-0.
Thank you very much. Delegate Gilbert, I think we may need to come back to your House Bill 1008. All right. Senator Norman.
Mr. Chairman, I move that we reconsider the vote on House Bill 1008, which we reported it and having voted on the prevailing side.
All right, it's been moved and seconded. The vote by which 1008 reported be reconsidered. All in favor signify by saying aye. Aye. All opposed. All right, bill is back before us.
I've never gone 3 for 3 in here, Mr. Chairman, so
Mr. Chairman,
Senator McDougal.
and I apologize to Delegate Gilbert. I picked up on an issue, and it's not with his change in language, it's with the underlying statute that this attaches to. Right now, the way it's written, an individual can get more time based off of this statute than the maximum penalty prescribed by the statute. And so Mr. Benjamin has some wording that would fix that. So even with the suspended post-trial, post-release supervision, a person could not get more than the maximum penalty under the statute. So I'd move the language Mr. Benjamin is getting ready to read.
Mr. Chairman, on line 64, after the word released, insert provided, comma, that no such term of recommitment shall cause the cumulative term of incarceration to exceed the statutory maximum period for the offense of conviction. Those last several words are in concept because I want to mirror statutory language elsewhere, but that's the amendment.
All right, Ms. Doucette.
Mr. Chairman, Mike Doucette, Executive Director of the Virginia Association of Commonwealth's Attorneys. Mr. Chairman, this statute was enacted 20-plus years ago for this particular purpose, was when you had a possession of a firearm by a convicted violent felon. It's a 5-year mandatory sentence. And this provision would allow for there be some court supervision after the expiration of that particular sentence. Maximum he could get is 5 years, and yet we wanted to have some way to control his behavior. So the bottom line is if a person serves that 5-year sentence, they get released from incarceration, they have this additional 6 months to 3 years. The violation, the bad behavior that causes the violation is what is being punished. And this is basically a mechanism in which the court maintains some control over that particular individual.
Mr. Chairman.
Senator McDougal.
So, Mr. Doucette, you're advocating that if somebody has the maximum sentence under the statute, that they could receive more than that for a violation of post-release supervision terms.
Mr. Chairman.
So that's not under just a violation of the court, which is what we typically do with some other failure to follow a court order.
Mr. Chairman, that's been the policy of this body for 20-plus years. That has been the existing law for 20-plus years.
Mr. Chairman, I personally, and nobody else might feel this way, but I personally don't understand how you could have somebody get more sentence than the maximum sentence that we have determined for the statutory offense. So if we don't change this, then that means people can continue to get between 6 months and 3 years more of a penalty than the statutory maximum that we've prescribed.
Mr. Chairman, so long as they behave themselves after their release, no, they don't.
Mr. Chairman.
All right, Senator Edwards.
I agree with Senator McDougal, but in addition, there's another problem. Once the judge imposes a sentence, 21 days goes by, you can't add to that.
And Mr. Chairman.
Is that what happens here?
No, the judge is doing this at the time of sentencing. He's saying, I'm sentencing you to 5 years, mandatory minimum on the possession of a firearm, and I'm imposing a fill in the blank between 6 months and 3 years additional sentence upon release.
At the time of the sentencing?
At the time of the sentencing,
Okay.
Mr. Chairman.
All right, I understand that.
All right. I think we've got it. The amendment is before us. Senator McDougal moves the amendment. Is there a second?
Second.
All right, the amendment has been moved and seconded. Clerk will open the roll.
Ayes 12, noes 3.
All right, the amendment is adopted. The bill is back before us. Is there a motion to report? You like it now, Ryan? All right, it's been moved and seconded. The bill be reported. Clerk will open the roll.
Thank you, Mr. Chairman.
All right, thank you. All right, next we've got Delegate Hope.
Thank you, Mr. Chairman. House Bill 53. House Bill 53. Oh, that's not.
Okay. Yes, sir.
Thank you, Mr. Chairman. Once someone is acquitted by reason of insanity, the court orders an evaluation. The only thing that this bill does is it allows for this evaluation to be performed by the department on an outpatient basis.
My understanding is it has to be recommended by the department and approved by the court under this bill.
That's correct.
All right. Anybody have any questions of the patron? Anybody from the audience wish to speak to this bill? All right, the bill is before us. It's been moved and seconded that the bill be reported. Clerk will open the roll.
Ayes 14, noes 1.
All right, that bill reports. Senator Stewart just wants me to have to explain it on the floor.
That's right. Good for him, Mr. Chairman. I have another bill before the committee, House Bill 1355.
Okay.
1355 came to me from the Virginia Association of Community Services Board. This would allow an employee or designee of a local CSB to change the receiving facility for a TDO issued for a minor if the employer designee finds a bed at a different facility, usually one that's located closer. We allow this under 37.2-809E for adults. The only thing 1355 does is extend the same flexibility to minors.
Okay. Anybody have any questions of the patron? All right, it's been moved and seconded that the bill be reported. Clerk will open the roll. All right.
Ayes 14, no 0.
Thank you, Mr. Chairman. I'd like House Bill 934, I'd like to see if that could go by for the day, because I have a couple of amendments that I think will improve the bill. And I need to
Mr.
work
Chairman,
with
that had an identical bill that went through rehab, I believe, so
We're going to re-refer that. So
Okay.
You'll have plenty of
Very good.
extra time.
Very good. Thank
All
you,
right.
Mr. Chairman.
Delegate Mieres.
Thank you, Mr. Chairman. I have HB 262.
All right.
Came out of the House with an amendment in the nature of a substitute.
All right. So my understanding is that this bill allows the court in a protective order to prohibit the subject of the protective order from terminating a cell phone service.
That's correct, Mr. Chairman. This is.
So how do you keep them, how do you make them keep paying?
So if I could just explain a little bit the background of this bill, and then I'll address the chairman's concerns. So what we have found is for the victim of domestic violence, oftentimes their cell phone is their lifeline. It's where they keep all their contacts. Particularly if you're a victim of a domestic violence situation and you are in a you've moved into a new area, and we've had situations of the victims of domestic violence literally being on the phone with either a loved one or the police and having their cell phone terminated. So this does a couple things. One, it enjoins the abuser from using the cell phone data in the protective order. It can enjoin the abuser from tracking down the victim. And two, what this simply says is it prevents them from terminating the cell phone plan prior to the natural expiration of the contract. So it's very different than the original
So
version.
basically, I mean, if this is a husband-wife situation, it says husband can't call Verizon and cancel the service, but if wife wants to keep it operating, she's got to continue to pay the bill if he doesn't, and it just keeps him from calling and affirmatively terminating the service.
That's correct, and it also enjoins him from using the data on the phone to track the victim down.
Okay.
And so it's very different than the original version of the bill.
What if all the phones are under one plan? So if you have a family plan, I don't have one particularly, but if you had one, then you don't have any choice but to continue to pay, because if you only paid for your portion of it, ultimately the provider would stop the entire phone plan.
It simply says you cannot terminate prior to the natural expiration of the contract. So in other words, it doesn't force you, if the contract's expiring in 2 months, does not force you to pay past the 2-month expiration of that contract. It simply says you're enjoined from terminating the contract prior to the expiration of it.
Nothing would prevent him from changing the contract and separating that out into a
No,
separate
nothing
contract,
would
would
prevent
it?
him from doing that, no. He could always call provider and attempt to change.
Mr. Chairman, it's,
Senator McDougal.
wouldn't that be considered a termination of the one line? I mean, if we're allowing that to happen, I think that that's pretty reasonable. But right now, we're saying that you have to continue to maintain the phone line. So I just.
Mr. Chair.
Senator Chafin.
Thank you, Mr. Chairman. Delegate, if a prenuptial agreement between the parties prohibited or provided for no spousal support, no support of any type, this term here would sort of violate that contractual obligation, would it not?
Well, I would probably make the argument that the prenuptial agreement would largely deal with the civil realm, and this would deal with a potential criminal case. I mean, this is a case of somebody who feels they're an imminent threat. They have gone to get a protective order. This just simply allows, in the protective order, if they so choose, to prevent their cell phone from being cut off. Now, if the committee has that much of a concern, if we want, and I believe in getting half a loaf, sometimes we can't get a full loaf, then I am fine with an amendment changing this to simply enjoining them from using the cell phone data to track down their victim. I'm fine with doing that at this point as well, because I think it really deals with two things. One, trying to keep them from turning off what oftentimes their only lifeline out to either the police or other loved ones that could save them. And two, also using the cell phone data to track them down and see where they are
Mr.
hiding.
Chair.
Who's that? Senator Peterson.
Delegate, let me ask you a couple questions. I don't
Yes, sir.
do a lot of this work, but first of all, I noticed the current subpart 8, which you would make subpart 9, already gives the court the ability to use any other relief necessary. So they can already craft a judicial order in this situation to accomplish this purpose. Here's my real concern, and that is when somebody files for a protective order, believe it or not, there's two sides to every story. And oftentimes, if one spouse leaves with the children and the other spouse is trying to find out where the children are, oftentimes the only way to do that is through a cell phone. I had an example where a family basically left the marital home and one of the kids called dad and said, we're in Pennsylvania. And it was a case I referred to a domestic attorney, but, oftentimes parents are trying to find their own kids in this situation, which in this case you would make a violation of a protective order. Now, again, it may be appropriate in certain cases, which is why a judge has flexibility, but I'm not sure in every instance when you're trying to track down somebody, it has a nefarious purpose.
I would simply say in the situation you described, nothing would prevent the victim from using the police to track down their child. I mean, they could call a detective, they can go to a magistrate and say, my child has been taken away from me without my permission. I mean, I would probably argue this doesn't prevent law enforcement from trying to track the children down. What we're attempting to do is those that have used the data on the cell phones when their victim has gone to a shelter and has sought refuge to track them down.
I made a promise that I was going to get the House members out of here. I suspect you either know whether you like this or you don't. I know there are two people who are queued up to speak, I believe. Anybody wish to speak in favor of this bill? Very briefly.
Yes, Mr. Chair. Valerie LaRue from Virginia Poverty Law Center, and we support this bill.
You really like it?
Yes.
Lawrence Dale, on behalf of the Family Law Coalition, we favor it. The introductory language says that the court may impose any of these. So if the facts are, as you said, we need to use the phone for locating children, the court still would have that discretion in doing that. But we really want the prohibition against the cellular phone termination, because that's a real problem. We have cases all the time where you have a vindictive, the person who's the respondent early on, whether it's valid later or not, is going to be very vindictive, and they're going to do anything they can. They cut off the phone, and that really terminates the ability to communicate, and it's a critical part of our life. And so I think this is a reasonable provision. I ask that it stay.
It's been moved. Is there a second? It's been moved and seconded. The bill be reported. Clerk will open the roll. All right. Bill reports. Thank you. All right. I think we got all the House patrons out, and we have Senate bill or House Bill 823, Delegate Knights needs to be re-referred to the Committee on General Laws. Is there a motion? It's been moved and seconded. All in favor signify by saying aye. Aye. All opposed? That's re-referred. And House Bill 934, did we already do that? It needs to be re-referred to the Committee on Rehabilitation and Social Services. Is there a motion? It's been moved and seconded. All in favor signify by saying aye. Aye. All opposed? That's re-referred. Next, we've got some House bills that are identical to Senate bills that passed. We've got House Bill 35, which is identical to Senator Spruill's Senate Bill 52 that reported out of Courts Committee 14-0 and out of the Senate 40-0. Anybody want to make a motion to report House Bill 35? It is identical. All right, it's been moved. Is there a second? All right, it's been moved and seconded that that be reported. All in favor signify by saying aye. Aye. All opposed? It's reported. Do you need a vote, Hobie? All right. All right, unless there's an objection, can we, after telling you not to, we can do these in a block. If anybody wants to pull any of these out and discuss them, let me know. But House Bill 755, does everybody have the list? 755's Delegate Leftwich's bill, identical to Chafin's 422. House Bill 840 from Delegate Bell is identical to Senator Howell's 457. House Bill 850, Delegate Pieces, is identical to Senate Bill 543 from Senator Mason. House Bill 1266, Delegate Toscano's, is identical to my 566. Okay. And House Bill 1360, Delegate Leftwich's, is identical to Senator Sturdivant's 982. And House Bill 1361, Delegate Leftwich's, is identical to Senator Sturdivant's 981. Is there a motion to report those in a block? So moved. It's been moved and seconded. Clerk will open the roll. Next, we'll do 1266. You have a question, or you want? Move to report. Okay.
Mr. Chairman, before we move on that, this is more educational than anything else.
We could all use that.
This is 1266?
Yeah.
Yes. Currently, if somebody is released on a summons and they go to court and they are convicted but receive a completely suspended sentence, what the law requires is that they then be remanded to the custody of the local law enforcement officer for processing. The practice in many jurisdictions, or rather the reality, is that once you are remanded, you are then held in the courtroom lockup with the entire cross-section of offenders in court that day. That can be for many hours. And then you're transported over to another facility for eventual processing, where you are again held, sometimes handcuffed, for another many hours. And so the reality of this process for somebody who has been released on a summons and has not been sentenced to a term of incarceration is that they are incarcerated for sometimes the bulk of a day. There's no easy, quick fix, because if the committee wished to do that, I think the stakeholders would need to be consulted. But it is a real problem for people who never imagined that they would be held in custody in a jail.
But that applies to the long list of other misdemeanors that are already covered by the fingerprinting requirement.
That is correct.
It's a broader issue that you'd like us to look at.
It is a broader issue, that's right. But when these bills are before us, it's my obligation to inform the committee of what's going on.
I appreciate it. Thank you.
Mr. Chairman, I have a question.
Senator Edwards.
What's the point of doing all this fingerprinting and all the rest for simple trespass or disorderly conduct?
Well,
What's the
we,
policy behind that?
well, because we are taking their DNA, and they are the only two arrestable misdemeanors for which we don't have a fingerprint requirement, and it's simply to clean up that inconsistency.
Well, Mr. Chairman, in view of what the council said, getting DNA is very quick, isn't that right? Very simple, very quick.
I think you'd have to be remanded as well.
Is that right?
For that, Steve, wouldn't you?
No, actually, the court, if somebody has not been sentenced to a term of incarceration, if this were amended, then the court could order such a person to report within 24 hours to the chief law enforcement officer. That would be the solution, but it's not one that I recommend without consulting with the sheriffs and other stakeholders.
Okay. All right. The bill's before us.
Second.
It's been moved and seconded that the bill be reported. Clerk will open the roll. All right, that bill's reported. We've got also House Bill 750 that is identical to Senator Cosgrove's bill dealing with the pre-sentence reports. It failed to report on a 12-2 vote. My guess is that we wouldn't want to extend any special consideration to the House member, but in any event, is there a motion?
Move to PBI.
All right, it's been moved and seconded that that bill be passed by indefinitely. Clerk will open the roll.
Ayes 12, noes 3.
Next, we've got House Bill 188 from Delegate Collins. Senator Stanley, this is similar to your Senate Bill 35. It actually is one of the few that passed.
We can fix that. Move to conform and report.
All right, there's a motion to conform and report.
Second.
All right, it's been moved and seconded. Clerk will open the roll.
Ayes 15, no 0.
All right, next we've got House Bill 378, which is, I believe, a Committee on District Courts or Judicial Council bill. Judicial Council? House Bill 378, which is similar to my Senate Bill 524. Is there a motion to conform and report?
Move to conform and report.
It's been moved and seconded to confirm and report. Conform and report. Clerk will open the roll. We didn't? All right. Well, let's fix it here rather than go on the floor. Senator Stewart moves to reconsider the vote by which we move to report that. It's been moved and seconded to reconsider the vote. All in favor signify by saying aye. Aye. All opposed? Yeah. Kristen, why don't you explain the
Mr.
situation?
Chairman, the only difference between your bill and Delegate Habib's bill is the language that's added on lines 31 and 32.
Oh, yeah.
The clerk in the appellate court may also request that any paper trial records be forwarded to such clerk.
I suppose the question is, do we want to encourage circuit court judges to become more accepting of paperless record? And I guess that we're enabling the Luddite tendencies of circuit court judges by adding this language, which allows them to ask for the transmission of the paper records. So I guess I don't object to not conforming, letting the House do that. It doesn't seem to be a problem to allow them to request the transmission of the paper files. Is there a motion to report, or do you want to be? We can. I don't know whether it's worth it.
All right, I move to report.
All right. It's been moved and seconded to report House Bill 378. Clerk will open the roll. And 482, Delegate Bell's bill, is the facility dog bill, similar to Senator McDougal's 420. What do you want to do with that, Ryan? Conform?
They're gonna conform yours.
All right, Senator McDougal moves, Senator Stewart seconds, motion to conform to Senate Bill 420 and report. Clerk will open the roll. Okay. Is that it?
Yes.
All right, that's it for the day. Committee will rise.